adjournments?
We've been here on a few different adjournments. I think this was the date and time set for the last settlement conference. Defendants requested a jury trial. There was an escrow order that was put in place January 5th.
This case starts with tension already baked in. We've got a landlord-tenant dispute tangled with missed payments, disputed escrow, and accusations of retaliation. Judge Simpson walks in ready to cut through the confusion, but both sides bring emotion and paperwork in equal measure. Right from the opening, you'll notice how technical details, like escrow timing, can decide whether a jury trial even happens. That's huge. A late payment by a few days can shift a case from a full jury to a bench trial before a single argument begins. Watch how the defense leans on claims of illegal lockouts and personal disputes, while the plaintiff sticks to cold accounting figures. Keep an eye on how Judge Simpson balances empathy with procedure. This is classic small claims courtroom pressure where one misstep with deadlines can rewrite the case.
That escrow order, though the sums have been paid properly, the timing of the order was breached. It's required to pay rent within the same time period as the lease, either the 1st or late by the 5th. We have escrow payments that were made February 15th, February 16th, that would have been late for the month of February, which would result in the waiver of the jury. So as a result, if the court is still inclined to proceed forward with the trial, it should just be a bench trial at this point. It should be set relatively quickly. I believe the escrow order would have required it to be set within 14 days. We have filed an answer. The court had adjourned previously when the defendant filed an answer to this, that their affirmative defenses could have been read as counterclaims. So we did file an answer to the end to avoidance of the affirmative defenses with the court. Ready to proceed now, though I still don't think there's a tribal issue of fact. I know the court has allowed it to go this far and is granting her the jury trial.
Do you have a response?
Yes, Your Honor, I believe that there are tribal issues. I can prove with evidence retaliatory eviction, illegal lockout, changing locks. I communicated the need for repairs, gave plenty of time. They were not done. This ultimately stems from a personal dispute by Ms. Serena's husband. I have been trying to get help from state emergency relief. I had to wait a little while for my appointment, and I had it last week. And thank God I was approved for some support up to $3,000, but the landlord refused to accept it.
After commentary, here the tenant reveals something major. She secured $3,000 from state emergency relief, yet the landlord refused it. That's not just pride, it's legal strategy. Accepting those funds could imply acknowledgement of a tenant's hardship defense. In landlord-tenant law, accepting third-party aid can complicate eviction proceedings because it looks like partial compliance. Judge Simpson keeps a neutral face, but the stakes shift. This isn't only about unpaid rent, it's about motive. Retaliation versus enforcement. Ask yourself, should a landlord be forced to take state assistance if it clears the debt? Or does refusal prove malice? The courtroom energy tightens. The audience feels the imbalance between legal technicality and human need. This moment sets the emotional tone for the rest of the hearing.
There has been no serious health hazard done, and they will not be able to prove that such a thing occurred. I will be able to share context.
Well, let me ask this. And it's a rather odd termination because one of the things is a failure to pay rent that was on there. But that aside, have the health hazards that were alleged, have they been corrected?
No.
No, I've been living in this winter with a broken window. I have been living without a thermostat because the landlord took it away. It's one of those Wi-Fi thermostats. Mitch.
What do you mean they took it away?
The thermostat argument seems petty at first, until you realize it's about control. A landlord allegedly removing a thermostat from a disabled tenant's unit is more than inconvenience. It may breach habitability standards. In most jurisdictions, tenants have a right to reasonable temperature regulation. Judge Simpson's quick question, "What do you mean they took it away?" shows disbelief edging into concern. The defense says it's set to 72 in another unit. The tenant insists she used to control it herself. Viewers, imagine living through winter without access to your own heat settings. This isn't just courtroom talk. It's a lived struggle that judges must decode between cross claims. Would you side with the lease's fine print or the person freezing at 2 a.m.?
So there, when I,
It's a three-level unit, Your Honor. The thermostat is in one of the other units, which is set to 72 degrees and stays there. She's never had access to the thermostat.
that's not true. When I moved in for 5 months, I did have a thermostat that I used, and I keep different hours. I'm disabled. I tend to be more awake at night when their schedule fits probably more of a 9 to 5. So what's happening is at night, the house is freezing cold when I'm trying to accomplish things. I've had issues with the lighting in several areas where.
Hold on.
Yes,
Hold
sir.
In the rental balance, so maybe we can get that part. What is the balance that you're claiming is owed?
The balance of rent, not including the escrow, Your Honor, would have been $5,390 through this month. I do believe escrow was paid this month, sometime around March 1st for $980. Otherwise, it would be additional.
Well, I don't have 980 in rent. Unless some came out. I have 870, which was paid on the.
Oh, yes, sir, because last month I paid a little extra ahead. So when I was here to make my payment, I asked the clerk to tell me the amount that was paid extra. So if the total balance should reflect the 3 months.
It may. I'm just saying, council had indicated a certain amount had been paid, and I'm indicating there was 870 paid.
The full amount was paid in pieces. Yes, sir.
From the onset of this case, Your Honor, it's $6,370 in total rent paid.
Say again.
$6,370 would be the rent due and owing.
6,300. Give me that. $70.
Just so the court is aware too, the lease expires April 30th.
The lease end date looks simple, but this is the ticking clock behind every eviction case. With just weeks left, both sides are fighting over money already running out of time. Judge Simpson subtly hints the dispute may be moot by expiration. Legally, once a lease term ends, possession often trumps emotion, yet tenants still push for dignity. Landlords chase closure. This is the quiet tragedy of housing court. Justice comes slower than the calendar. Ask yourself, when the end is inevitable, should courts push for settlement or let parties battle it out for principle? Simpson's calm tone hides the urgency underneath.
What do you have as the amount of rent?
I have $2,939.98.
All right. So the lease expires April 30th.
Correct, Your Honor.
Are you intending on moving, or what is the?
Yes.
Okay.
I wanted to stay at my apartment.
Pardon?
I wanted to live in my apartment for the full lease term. I'm planning to move out at the end of April.
Okay. All right.
So I would like to see proper accounting of the claim of that amount, because the last time I requested, it was not done properly. And
What do you mean the last time? I'm not sure what you're referring to.
At the December 22nd hearing, Your Honor, defendant requested an accounting of the rents that were paid. We did a notice of filing showing both her payments as well as the payments of her prior co-tenant, because
that is not true. That is not true. I have not received that.
Communication collapse, classic in housing disputes. The tenant swears she never received an accounting of rent. The attorney insists it was mailed. This is where documentation becomes a weapon. In housing court, I sent it versus I never got it can change credibility fast. Judge Simpson keeps composure, but you can sense irritation. Each missing document adds friction. For viewers, note how simple miscommunication morphs into legal contention. If you were the judge, whose word would you believe? The organized attorney or the emotional tenant? These moments test courtroom patience and reveal how procedural slip-ups fuel bigger battles.
That's what I asked for.
Hold on.
Yes,
Okay.
I'm trying very hard.
Okay. And you're saying you didn't receive it.
I did not receive anything that reflected what my roommate contributed. I did not see that, what Attorney Backman just said.
And
It's
Your
not
Honor, that
true.
was addressed at the last hearing where she indicated that
thought it
wasn't
was.
a proper accounting. She didn't like the way the accounting was drafted, but it was in and of itself an accounting of all of the rents paid by both sides showing.
And maybe we review it together.
We who?
He's saying it is, I'm saying it ain't. Let's,
Okay. Here, I think that's what let me put it this way. What I'm looking is what issues at trial I'm gonna have to deal with. Obviously, I'm gonna have to deal with that. So,
I have an additional copy, Your Honor, for the defendant, so I'll make sure.
Okay.
yeah, and I heard you said is this the answer? Because I didn't receive any additional information. You said you filed with the court?
Your Honor, I have an additional copy of the answer to the affirmative defense.
I mean, how do I get that?
These were all mailed, Your Honor.
Well, they haven't been received yet.
okay, now they have. All right. So what the court's gonna find regarding trial, because obviously we're not gonna be able to resolve it here at a final summit conference, is that given the way that escrow was paid, the problem is that escrow needed to be paid within the time frame specified, and it wasn't. It was paid, all right, but you have to. No, I'm not faulting you for that. I'm just
Which
saying.
month was it? Because this month I came in as soon as I got my social security deposit. I only get the one amount per month. And
No, I get it. I mean, it's not, but what I'm saying is there's timeframes for it to be paid.
Timing kills cases. The judge reminds everyone, escrow must be paid on schedule, not eventually. This line explains why she loses the right to a jury. In law, deadlines are sacred. Miss a date, lose leverage. Yet Judge Simpson softens the blow, acknowledging her reliance on monthly benefits, a subtle sign of empathy amid formality. The takeaway for viewers: courts weigh compassion against procedure, but procedure usually wins. Would you call that fair or mechanical justice? The audience feels both tension and pity, a reminder that legality doesn't always align with equity.
What I did is I think that the jury has been waived.
Correct, Your Honor.
And so that's it. That doesn't mean that you don't get a trial. I delayed it in terms of what would normally happen is I would have said, jury's waived, they get an immediate trial. The problem is you had not yet gotten all of your things together to get to the court. And so I was allowing that to happen. That doesn't really affect the waiver. It more affects the timing of the trial and then the payments. So there will be a trial on possession. I will set a trial on possession. Here is my real fundamental question for the parties, because I can get you in. It's time in April. And realistically, just thinking, the lease expires April 30th, right? There'd be a trial. We could certainly spend our time on a trial or agree to a move out at the end of April, because I mean, you're going to somehow or another, you're going to have to figure out the figures of what may be owed, right?
I can do
But, and I know you can do that. You're going to come to a different number than that. I know how I've been with you guys long enough to, I know what's going to happen. So, but what I'm saying, I guess my bottom line to it is I'll give a trial date. That's not a problem. But the reality is you're going to be moving out at the end of April.
The case turns practical. Instead of prolonging trial prep, Judge Simpson offers an off-ramp. Move out by April end, skip the drama. It's pragmatic law. Save the court's time, save the tenant stress. Yet emotion lingers. The tenant just secured aid. Now she's told moving out is the cleanest fix. This moment mirrors many real cases where justice feels like compromise. For landlords, it's closure. For tenants, it's surrender. What would you do? Fight for damages or walk away free? Judge Simpson's calm realism contrasts the emotional chaos in the room.
Right. And that's what they're looking to have happen. I don't know why we can't just figure everything out with a move out date of April.
And I'm okay with that. I would be willing to negotiate with them, but after I got the approval, they said, yeah, we're gonna help you with the 3,000 from SOS. The total amount that I had was just under 3,000. So here I am happy. I'm gonna get some
So
support.
hold on a second. So did they say they were going to do that?
Yes, I have the email that I can share with the court. Miss Alicia, last name.
So Alicia, that's fine.
Yeah,
From SOS.
Yeah, and I have a
So-
letter that states the landlord declined to participate in the program, so they're suing me for money. I was able to get money, but they don't want to come and, I was, Alicia basically said, which is my, I have an email. It says that, you know, I've been waiting all this time for the extra help, so you know, they're kind of just throwing everything on the wall to see what sticks. They're claiming rent, but the rent was withheld because of a failure to secure a property that's habitable. The landlord busted off the locks. I lived without locks in my apartment for several months. I had people break
Okay,
in.
I'm not here to try this right now. Okay. If you say that there's assistance, they declined to participate in the program, then I can't do anything about that. I can't force them to do that.
Yeah, it's just odd, right?
Pardon?
It's odd.
It's not necessarily odd. I mean, some landlords
Honest, the first
participate,
thing
some don't.
I'll speak with my clients as a person.
I was
Okay.
wondering if they should contact Zorica instead of Mitch, because Mitch is the rude.
All that aside, Your Honor, I don't know if the court would prefer, given that there's an indication from the defendant that should be moving out at the end of the month, to set the trial in May, just not to waste the court's time. I hate to kick this out any further.
By proposing a May trial, the attorney flips the calendar into leverage. Delay becomes a strategy. Every extra month means rent accrues, pressure mounts. Judge Simpson knows it. The defendant protests, wanting damages for retaliatory eviction. It's a chessboard, move out versus monetary justice. The judge subtly frames May as efficiency, not avoidance, yet both sides read it differently. For viewers, this is the quiet heart of civil litigation. Time is currency. Who benefits from delay here? The side with resources or the one scraping by?
My fear is that we'll have the issue over not just possession, but damages and rent. That'll be the bigger.
Because there wasn't a permanent ongoing problem.
So possession is already handled. Setting it in May save the court time.
You have any problem with me setting a May trial date then instead of an April
I
1?
preferred the jury trial that I requested.
I know,
My
and
client's
I'm deeming that it's been waived.
Okay,
So,
I'm willing to be at trial whenever is convenient for the court.
okay, but what counsel's suggesting is a May trial date because you said you're going to move in April. And so it may be that the trial may not be necessary. It can be
I
resolved
want the
that way.
trial because it's a retaliatory eviction and I want my damages.
I get that.
Yeah.
But the certain issues regarding possession and other things would be done with if I set it in May. As opposed to if I set it, it's going to be early April. And here's what I don't want to run into potentially is a situation where, let's say, and I'm not saying how I'm going to rule, but I'm just saying, let's say I rule in their favor. And then there's an order of eviction for, let's say, April 15th. And then, but you're going to be out the 30th anyway.
I'd be willing to be out tomorrow if they would just accept the $3,000 and say I don't owe them any money and we move on. It's only a month left.
Okay.
Otherwise, I want.
Then that may be an option you guys can work out. And let me just say this, I don't know this for sure. Part of the reason why they may not have accepted the 3,000 is because the funding technically is to preserve housing. So the question of you moving out at a particular point in time may affect that 3,000 and whether or not they pay it.
What I was, okay.
Okay, well, it's a hypothetical, but there depends on what program it's coming from, is what I'm saying. So it may be that it's not entirely as simple as that, because what used to happen is somebody would get an email like you did. They'd contact the landlord, and what they want is they want then a lease that continues on. And if the landlord said, no, that's not going to happen, that will look like their rejection. I'm just saying, I don't know that that happened in this case, but I could see that potentially being an issue in this case. All right.
Potential, not possible.
Okay, however you want to phrase it. All right. So here's what I'm going to do. I'm going to indicate the jury trial's been waived. I think the best thing to do, folks.
So what month was it that I missed the window?
Well, actually, the first period in time, you actually would have missed it.
When it was first ordered?
Yes, ma'am.
It was ordered after the payment due date, wasn't it? We're talking about.
Well, there was escrow was prorated, and then when you came into, hold on, when you came into February, you did a partial,
I've already.
and then if you're gonna try to overtalk me, I can't do it that way.
How else may I respond to things that I'm concerned about? I don't have, I will write them down.
All right. That's my ruling on it. I'm also going to then set non-jury trial in this matter. Give me a May date. I need it before then.
Do Tuesday, May 7th, you know?
Thank you. That non-jury trial, May 7th, 2024 at 9 a.m. Right. And that's what we do. And you're going to check into with SOS.
Yeah, sure.
And that.
Do you have their contact info I can share with you?
That's what I was going to suggest. If you can get the contact information so council knows, and then that way, maybe that'll work out that back amount in some way. Okay.
Thank you, Your Honor.
Thank you.
Case closed for now, but lessons remain. Judge Simpson confirms a non-jury trial for May 7th and urges both sides to coordinate with assistance programs. His closing tone blends fatigue and pragmatism. This hearing shows how civil courts juggle empathy, paperwork, and precision. A late escrow, a broken thermostat, a refused aid check. Each detail builds the story of justice strained by process. Ultimately, no side walks out feeling victorious. For the audience, remember, in housing law, deadlines rule, and emotion rarely wins. If you found this case as shocking as we did, hit like, share your thoughts below, and subscribe for more courtroom breakdowns that expose how justice really works in everyday trials.